Good afternoon. Not legal advice. Quick by a lawyer. I wouldn't trust what a lawyer says when they say quick, but a briefer video on Alpine GTI, a little bit about Mullen and a little bit about MMTLP. All exciting. Not legal advice. Like, subscribe. Please like and subscribe and comment. I do look at the comments, so please put them out there. Hopefully, everybody can hear this one. Um, Going with another mic this time, so hopefully that works out well. Before I get into discussion updating, because there's some updated news as to Alpine, I bought the worst thesaurus yesterday, if I could say it. Not only is it terrible, but it's terrible. Anyway, hopefully you like that one. So let's give a quick update regarding GTI and Alpine. So GTII is a company that's being naked shorted purportedly, and a lot of people are waiting for it to explode. Whether that happens or not, I can't tell because it's not legal or financial advice. But anyway, that's what people are expecting. And one of the catalysts for that is the broker Alpine being put out of business. Alpine apparently facilitated the shorting of that stock, and many people believe that if Alpine is permanently expelled, that will facilitate a run, a short squeeze, or a big movement. So now moving to beautiful Alpine, I call them not only the Alpine, but if you spell it correctly, it also spells scumbag. But between 1984 and 2022, 40 separate incidents of being punished by either the SEC, FINRA, or an analogous agency, 40 different times for various violations. I think it's April of 2022, they were again punished, but this time because they were ripping off clients and all the other various things they were doing, they were expelled, and along with the cease and desist order. But that order is not final until certain things happen. So time went on, and even though there was a cease and desist order saying that they shouldn't do certain things, time went on. And in October of 2022, they filed a separate lawsuit contesting FINRA's ability to do what they were doing, to punish them, to conduct proceedings, etc. And they asserted they were unconstitutional. In or about April or May of 2023, FINRA, after determining there were 35,000 violations, went after Alpine to shut them down. They initiated a proceeding. They had a couple days of hearings. Alpine went into court in the district court to try to get an injunction. It was denied. So after it was denied, they went into the appellate court, and eventually a 3-judge panel agreed to a stay so that the expedited hearing that would have expelled Alpine could not go forward. And that is now on appeal, and that's what I'm talking about today, because the first appellate brief was filed yesterday. FINRA is represented by Gibson, Dunn and Crutcher, which is a big firm that represents a lot of financial clients. In the brief, I reviewed the brief. So the brief was filed yesterday. It's about 55 pages in length, including all the trimmings. There's citation to new cases, questioning or testing the authority and process of FINRA and the SEC. And by the way, notwithstanding whatever, so right now I'm giving you the overview of what the brief says. I'm not giving you my feelings about whether I believe or agree with their position, but this is what they're stating in their brief. And I'm summarizing it, obviously, because it's 50 pages long or 55 pages long. So anyway, they basically cite to new cases that are attacking FINRA and the SEC's authority and perhaps independence from the executive branch. And ultimately, their position in this brief, and it's consistent with other cases that are either going up to the Supreme Court or recent cases, and with Mr. JR, we talked about Jurkowski that's going up to the U.S. Supreme Court. Anyway, a lot of these cases are questioning especially the prosecutorial sections of the SEC and FINRA. And that's what Alpine is doing in this particular appeal. And basically, the point that's being made is when FINRA is acting to enforce federal securities laws through their delegation through Congress and the SEC, they're basically conducting state action. They're acting as an agent of the state. And if you're conducting state action, then you're subject to the constitutional provisions that protect everybody, including the due process rights. And that applies not only to the prosecutorial side of FINRA, but also in what penalties they determine. So their argument basically is that that's state action and you must comply with the Constitution, and we must be afforded proper due process. And FINRA has its own rules and operates as an agent of the SEC, and like a government agency, has immunity. And in effect, it's carrying out core executive branch functions without having been appointed by the executive branch. So the hearing officers, et cetera, that FINRA uses and that the SEC uses aren't appointed or confirmed or controlled by the executive branch, and they should be. So that's an argument, and that's an argument that's been placed in other cases. And the fact is they enforce federal securities laws, and their penalties have the same force and effect as if some other federal court was imposing that. And they're also asserting specifically that, as I indicated, but maybe didn't use the term, it's a violation of the Appointments Clause of the Constitution, that the executive branch should be appointing the judges, hearing officers that would be conducting hearings involving federal securities laws. They also argue, and I find this part somewhat humorous, that it's equitable for them not to suffer the consequences of an expedited proceeding. And again, the focus is on the expedited proceeding because this doesn't provide the same kind of notice that the other proceedings would apply. And even though in my opinion, these guys are scumbags, they've engaged in numerous acts of misconduct, their argument is because you could not trust basically the judiciary of FINRA, the April 2022 findings have no force and effect also. So you can't just, even though they don't say this, you can't presume that we're scumbags based upon that April 2022 decision, because that was not done in a fair and partial way. And also, in effect, it's not final because, and I can't understand this, because the NAC, I think it's the National Judicatory Council, which is FINRA's appellate arm, has yet to affirm and review that April 2022 decision. I can't tell you why they have not, but until they do that, it's not final. So because it's not final, FINRA couldn't have kicked out Alpine. So two things. One, why don't they get that final, at least push that? And two, go into federal court and go after Alpine. I don't know how many times I can say this. Stop protecting the agency's tail and protect the people you're supposed to protect, and go into federal court. And if these guys are scumbags and they're stealing money and they've had at least 35,000 violations since April 2022, go into the federal court. So again, the fact that this was an expedited proceeding with little notice further compromised due process. And Alpine, in effect, would want that 2022 verdict to be tossed out. And I'm not going to argue about that because I know they're scumbags. But again, FINRA could go right into federal court, have a receiver or third party take over now for Alpine. They'd be out of business. And it would have nothing to do with FINRA or the SEC. It would be the courts using appropriate due process and complying with the Constitution and ending up with the result that everybody wants. So that's kind of the nature of it. And again, the bottom line is the arguments are state action, that FINRA is enforcing federal securities laws, and the violation of the Appointments Clause, that this is really executive functions that need to be confirmed, and the judiciary of FINRA and the SEC needs to be appointed by the executive branch, and this was not done. But it doesn't preclude FINRA from doing anything else. So from this point in time, FINRA will now file an opposing brief, so that'll be done by Gibson Dunn, and they'll contest everything that I just mentioned. And they'll claim, I'm sure, in a different way, that Alpine are scumbags and don't deserve this level of due process, and they've gotten due process and multiple hearings, and they're blocking it. And one thing I expect Alpine to come back with, because they kind of referenced it before, is why did you wait for a year then if it was such a dire situation and you need the action now? You needed to act in an expedited fashion. Why did you wait a year? And I think it's a good question. Why did FINRA wait, and why didn't they act, even knowing at that time that the public was at risk? But anyway, so FINRA will file a brief probably within about 30 days. I'll review it. I will also kind of summarize the arguments that are made. Then there will be likely a reply brief, and then this matter will be set for oral argument. And again, I'll keep you apprised, and if there's any action by FINRA outside of this, we'll obviously keep you apprised. And that'll bring you up to date through the 28th as to Alpine. Now a quickie, I saw today that Mullen, through Wes Christian, filed a lawsuit against some brokerages, including TD Ameritrade, Schwab, and some others, alleging, amongst other things, market manipulation and unlawful stock trading practices. Now, I'm not going to suggest what other companies should do this, but would this also apply to like MMAT, Nextbridge, GTII, Finger? Could they just sue the brokerages and put the pressure on the brokerages where there are manipulated situations, naked shorting, etc.? I think that's something that they should look into, and I wouldn't be surprised if they weren't looking into it at this point in time. Anyway, hope that helps, brings you up to speed on a couple of things. We'll keep you up to date. Take care, be well, and have a great day.